Operation of law is when an agency relationship ends by operation of law. For instance, Robert and I enter into a relationship, I die. By operation of law, the agency is terminated, right? Once it's terminated, the agent can no longer represent the principal or bind the principal with contracts. But that's only true in certain situations, which we'll talk about in a minute. So, the agency can be terminated by acts of the parties, which include mutual agreement. We agree. A lapse of time. This agency was terminated on December 31st, 2014. When that time comes about, the agency terminated. Automatic. Purpose achieved. Robert hires me to sell his house. Once that purpose is achieved, the listing and sale of that house and the payment of commission, agency terminates. Occurrence of a specified event. Robert hires me to keep his pet while he goes on vacation. Once that specified event happens and is done, agency is terminated. With it so far? Yeah. Notification is required. This is the key. The principal is responsible to give certain parties notification when an agency terminates. Any party who dealt with the agent must be given direct notice. So, Robert and I are principal agent. I'm the agent. Robert terminates my contract. However, the person that I was negotiating with on Robert's behalf is, what's your name is? Ellen. Robert, by terminating me, has an obligation to tell Ellen that I'm no longer an agent of Robert. If he neglects to do that, then what do I still have? Apparent agency. Apparently, in Ellen's eyes, I'm still an agent because you neglected to tell her that it was terminated. So if I go to Ellen and fill out a contract that binds you, you are responsible. So you have a duty to tell any party that dealt with me that I'm no longer an agent. Direct notice. That means either written or verbally. You got to get to Ellen and say James is no longer my agent. Preferably in writing, right? Because after the contract is done, what's Ellen going to say you didn't tell me? Right? So you want to do it in writing, right? Now, on an express agency, is it required that an express agency be in writing? Or can it be oral? It can be oral, right? It's always best to put it in writing because of disputes, right? But it can be an oral. Robert could come to me and say, James, I'd like you to contract with Ellen. It's a contract. I say, okay. You got a binding contract unless it's real estate where it has to be in writing, right? So I can go to Ellen. Hey, Robert, I'm the agent. I'm da 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 da. Let's sign this contract. She signs it. Robert's back. Right? When I cancel, I got to give a direct notice, and I prefer to be in writing so that she can't say she didn't get notice, right? Parties who have knowledge of the agency must be given direct request. So, Robert contracts with me and terminates me as his agent, right? Jordan knows about the agency, but she hasn't done any work. I'm contracted to work with Ellen, but Jordan knows I'm an agent, right? You owe an obligation to give Jordan a constructive notice that I'm no longer an agent. You don't have to give her direct notice. It's preferable, right? But you can give constructive notice. What might that be? An article in the newspaper of general circulation for the area where we do business and says something to the effect of James is no longer an agent of Robert Guy. That way you protect yourself from those who know that I'm an agent but aren't necessarily people that work for me. Got it? Constructive notice simply means a notice of general circulation to the specific area where I would be known to work. Alright? have no knowledge of the agency are not on any notice. So I don't have to call people in New York and let them know that, or Robert does. I have to contact people in New York or Arizona and let them know that I'm no longer an agent because they have no knowledge of the agency. Yes.
What would the notice be for someone that is like a scout who works across the country? What area?
In that case, you would look at the areas they primarily would be scouted for. So let's say it's an NBA scout, and I terminate their agency. What would be my obligation? Contact all 28 or 29 or however many NBA teams there are and say, James McDade is no longer my agent. Right.
Not just one primary, but every.
Right. Everyone who's dealing with me, if it's the Phoenix Suns and Brooklyn, whatever, I have to contact them specifically, right? For the rest of the NBA teams that know I'm an agent, constructive notice might be an article in the paper, or maybe USA Today, national newspaper, right? That would do. Okay? But I don't have to contact, the German league or the European league and let them know, right? Because they have no knowledge of it. Yeah.
And last question related to that is some of these things may take a period of time to get communication about every party that needs to.
In between what happens?
Right. In between. Right. So now for the apparent agency, that would be binding until every party has that notification.
Yes. Absolutely. Good question.
The
irrevocable agency is simply where it's not revocable by the principal. That's a mortgage contract, for instance. Right? Principal in a mortgage contract is the homeowner. The agency is the bank. Principal can't revoke that contract until the loan is paid off. That's one of the few examples of an irrevocable agency. Yes.
Could direct notice be like an email? Just saying that.
Termination by operation of law is the death of the principal or agent terminates an agency contract by law. Period. Insanity of the principal or agent terminates agency by law. Bankruptcy of the principal, but not the agent. Why? Because the principal's credit standing is what's important in the agency relationship, not the agent in most cases. And bankruptcy means real bankruptcy, not insolvency. Okay? Insolvency is simply you have more liabilities than assets. You're insolvent. But you're not necessarily bankrupt until you file a petition with the court. Okay? Impossibility of performance. I contract with, what's your name? Kyle? I contract with Kyle, or Kyle contracted with me to sell his horse. If the horse dies before I sell it, it's impossible for me to perform the contract, right? So contract operational law terminates when the horse dies. Change circumstances. I'm a real estate agent contracted by Alina to sell her house. I go out to the house, it's listed for $100,000. I go out to the house and look in the backyard, and there's this black stuff moving out of the ground. Black gold. Oil. I have a contractor come out and assess it, and he said, hey, there's $5 million worth of oil in the ground. The agency contract terminates by operation of law because of the changed circumstances. I can't sell this house for $100,000, which is what we contracted for. It's worth $5 million. Right? My contract is terminated. I got to now renegotiate with the principal to see if they still want me to sell it for $5 million, or they now have the ability to go get someone who maybe is more high profile and selling $5 million houses. Or someone else who can do further examination to see what maybe the value is $10 million. Who knows? But my contract terminates by operation of law because of the changed circumstances of what we were contracted. Does that make sense? Someone say no? Yes? Yes? Okay. War between the principal and agent countries. If I have a contract with Angela, and Angela's from France, and I'm from, England, and we go to war with each other, contract terminates because it's assumed it would be impossible to perform, right?
It's got to be declared war, right?
Declared war, yeah.
Not just conflict.
Right. So termination of an agency employment contract, termination of an agency contract in violation of the terms of the agency contract. If that happens, the non-breaching party can recover damages from the breaching party. There's a distinction between the power and the right to terminate an agency. Everyone knows the difference between power and the right? No? I'll give you an example. We have that call. Miss, what's your name? Athena? Everyone answer this question. I don't know Athena, but I have a gun in my hand. I go up to Athena, and she's never done anything to me. Right? And I have a gun in my hand, and I have my finger on the trigger. Do I have the power to shoot Athena? Yes or no?
Yes.
Yes? Do I have the right to do it? No. That's the difference between the power and the right. You have the power to terminate an agency relationship at any time, principal or agent. Whether or not they have the right to do it is critical. Because if I have a contract that says X, Y, and Z, and I terminate that contract before X, Y, and Z is accomplished, I could be guilty of a wrongful termination. If I'm a real estate agent that's been hired for 3 months to find buyer ready, willing, and able to sell the Seam's house, and after the first month, the Seam comes to me and says, James, I revoke your authority to sell my house. Do I still have the legal right to sell her house? No. She's revoked my authority. Does she have the power to do that? Yes. Does she have the right to do it? If we sign a 3-month agreement, and after the first month, after I didn't do anything wrong, she just simply decides to terminate me, she has the power to do it, but not the right. It's a wrongful termination, and I can sue her for breach of contract. What is my damage? Loss of commission. She denied me the right to make the commission. Everyone see that? The difference between the power, you can always do it, but you might not have the right. And if you don't have the right, you might be liable for wrongful termination. Yes?
Are lawsuits over that particular issue common?
Yes. Especially in real estate. I don't like you anymore because I just don't like my lifestyle. I just don't like you.
It's just after a short period.
I'm just terminating you. Okay. I don't want to. Well, when you work with an agent, they were going to make a $10,000 commission.
Okay, yeah.
And you just denied me that, and I spent 2 months of my own money marketing your house, open houses, making phone calls, showing your house. 2 months in anticipation of a $10,000 commission, and in the second month, you decide you don't like me anymore. Not because I didn't do my job, just because. To me, it's going to be worth it.
Okay.
Right? Now, in practicality, most agents don't do that just because they don't want to have a bad relationship with their client. They probably try to talk about it, but they do have the legal right because it's a wrongful termination. You have the power to do it, but not the right. Got it? Okay. Now, the difference. Revocation of authority is simply the principle saying, I revoke, or I take back the authority I gave you. I revoke it. Take it back. When the agent does it, they renounce their authority. They say to the principal, I give give back to you the authority you gave to me. Got it? Revocation and renunciation. That's chapter 1. Any questions? See how quickly we can get through chapter 2. Yes, sir.
So for you just got your advice, real estate transactions have to be a written contract. Use the contract to allow someone to have advice on your behalf of real estate. The contract just to allow you to do that has to be written as well.
To allow
like
me
to you to be, can I express give you be my agent? Can you?
It's got to be right.
That's all right.
Yeah, because it deals with real estate contracts. No,
No,
it's the actual contract. Yeah, no real estate agency does take a agency agreement from the owner. Right? It's $10. Yeah, there's the Department of Real Estate has all these forms: purchase and sale agreement, listing agreement, all that stuff. It's all has to do right.
pretty much anything related to real estate.
Yeah. All right. So we talked about a little about the duties of the agent. Let's look at some of the duties of the principal. And this kind of is a recap. Duty of performance. The agent's duties of the principal. The agent has a duty to perform, right? To actually do the thing that they're asked to do in a way that is based on a reasonable person in that position and what they would do. They have the duty to notify the principal of anything that they know that pertains to the agency because that knowledge is imputed to the principal, right? They have a duty of loyalty, to not deal unfairly with the principal. And they have a duty of accountability. Show the principal what you've done and why. Okay? That's the 4 basic duties that an agent owes to the principal. And the agent breaches this duty of loyalty when they self-deal. In other words, an agent is hired to find a house for a potential buyer, and the agent sells that buyer their own house without revealing to the buyer that they have an interest in that house. That's self-dealing. That's a breach of the duty of loyalty. Agent would have to say, hey, I have a house that I own that I'd like to throw in the mix for you to look at. Then the agent can do that. Usurping an opportunity. Agent is hired to buy widgets for the owner of a company. Right? The agent goes to the widget company and negotiates a great deal. Right? It's the widgets for 10% below market. It's so good that the agent says, I should buy this for myself. And I'll sell these widgets on the side, and I'll find something else for my principal. Usurping an opportunity. That opportunity belongs to who? It's the principal. Right? I have an obligation to offer that deal to the principal. If the principal says I don't want it, then I can have that opportunity. But if I take it myself, it's usurpation. A breach of the duty of loyalty. Remember, loyalty is based on what? Trust. Right? I have a fiduciary obligation to be trustworthy to the person who's hired. I can't compete with the principal. I can't misuse confidential information, and it's difficult to meet a duty of loyalty to 2 parties with conflicting interests. Dual agency. Everyone know what that is? I'll give an example. That really happens. In a dual agency, it's usually prohibited because of the reason that how can I fulfill my obligation of loyalty to Robert and Alina when they're opposite parties in a contract? I have a conflict of interest, right? How can I serve his best interest and hers at the same time when they compete, and I'm the one that's doing it? You can't do that, though. One case where you can do it. Maybe for real estate. As a real estate seller. Alina can be a buyer. I listed the house for Robert. I held an open house, and Alina came by and said she liked the house. Alina, do you have an agent? No. Would you like an agent? Yeah. Sure. Can I do that?
Yes.
Is that a conflict of interest? Apparently, it would seem to be. How can I get my job to Alina is to get her that house for the lowest possible price? That's my job. That's what I'm supposed to do as her agent, right? For Robert, my job, what I'm supposed to do is find him a buyer ready, willing, and able to buy the house for the highest price possible. That's my job. I have a legal obligation for that. So how can I meet my obligation to give him the highest price and to get her the lowest price at the same time?
And the private price is great.
We'll get to that. So my job has an inherent conflict of interest. Because, just like Joseph said, from my standpoint, the higher the price, the more commission I get. So I have an inherent conflict just representing you vis-a-vis her. Because if I get a higher price, okay, I get more commission out of your pocket. Because you're the one as the seller that's paying the commission. Right. Right. Not necessarily. Here's the way it's going to work. There's one way it can work. What is that one way? Disclosure and consent. As long as I say to Alina, I can be your agent if you agree that I can also be Robert's agent. Alina says, I don't have a problem with that. Sign this document. There's a real estate form that's required to be signed that says, I understand that this is a dual agency and that James represents me in this as the buyer. I'm going to take that same document to Robert. I'm going to say, Robert, I found your buyer ready, willing, and able. She doesn't have an agent and she wants to be your agent. Will you consent to that? If Robert says yes, I say good, sign this. Robert signs. I understand James is a dual agency. I agree to that. Cool. I'm good. If either one of them does not consent, I cannot be a dual agent. If I do it anyway, I forfeit all commissions. Okay? Make sense? Can't spend too much time on it. Does that generally idea make sense? That's a dual agency. They better. You better make sure that they do it in because if they say they don't, then you're probably not have a time problem.
I've seen examples where an agent represents the bank for someone that has a bank. Often the bank, when banks are able with that situation, they're like
where the agent does
their agents of primary fiduciary obligation to the bank because it's selling for the bank, and then they come in contact with someone that doesn't have an agent. The person may do it, or the bank from experience.
Well, the bank may or may not, but the person is most likely going to be representing the bank's interest more so than the others. So, probably wouldn't want to do that as a buyer because it would be inherent conflict. I know you might know, well, James is a good guy, he knows he's going to get you the best deal, but James is also this person's representative, and this person is the one that's paying the commission. And the higher the price, the more money I get. So, really kind of psychologically, I'm probably going to push you to get the higher price, right? And then you're at a disadvantage. And you're the person usually that's going to be able to complain to the Department of Real Estate that I must have told him what my top price would be. So that's why, as an agent, I'm probably not going to want to do it because of that liability that I put myself in. Because either one of them, all they have to do is contact the Department of Real Estate and say, hey, this dual agency, I feel I was ripped off. One of the others says, hey, I know you told the other person the price. You have no way of really denying that yourself. And then you lose commission and possibly your license. So a lot of agents won't do it.
But you will be earning 2 commissions.
No, 1 commission.
Just 1.
you'll get both sides, which I don't want to get into. Basically, when you sell a property, she has an agent, all right? We split the commission. Her agent gets 3%, I get 3%, if it's 6% commission. $100,000 house, 6% commission is $6,000, right? My final buyer ready, willing, and able that has an agent, they're gonna negotiate with me for the price. Once the house is sold, I get 3,000. The other agent gets 3,000, right? That's the 6% commission that sell pays. If that person doesn't have an agent and I'm their agent, I get both sides, the full 6,000. So that's an incentive, right? But the problem is that is in jeopardy if either one of them later complains that they were treated unfair. That's why a lot of people don't work, just because of the liability side. But yeah, I get the whole commission.
The whole 6%.
The whole 6% because there's no other agent to split it with.
Right.
Okay. All right. So, contract liability to third parties. A principal who authorizes an agent to enter into a contract with a third party is liable on the contract. The principal. And the third party enforces the contract and recovers damages from the principal. The agent can be held liable when there is a fully disclosed agency, partially disclosed agency, and undisclosed agency situation that we'll talk about. In a fully disclosed agency, that means the agent fully discloses who the principal is and the fact that the agent is working for a principal. So in a fully disclosed agency, if I'm Tonico's agent and we go out and I negotiate with my widget and I say I'm buying these widgets and I'm signing this as James McDade, agent for Tonico. That's a fully disclosed agency. I acknowledge that I'm an agent and the person who I'm an agent for, the principal. Fully disclosed, right? In that case, the agent is no longer liable on the contract. The principal is. So the principal will be bound to the contract, not the agent. Got that? In a partially disclosed agency, the agency is disclosed, but not the principal. In this case, Allison hires me as an agent to find her a house. I find a house and I sign it as James McDade principal or James McDade agent. But I don't say who I'm an agent for. Partially disclosed agency. The third party knows an agent, but they don't know who the principal is. Partially disclosed. Right? In that case, both the principal and the agent are liable on the contract. Why? Because the third party has to rely on my credit worthiness in order to do the deal. Because they don't know who the principal is. That's too fast? No. Partially disclosed. In an undisclosed agency, agency is not disclosed at all. Just James McDade. In an undisclosed agency, both the principal again and the agent are both liable. Why? Because again, the third party is relying on the agent. Why would we have an undisclosed agency? Let's say Walt Disney wants to buy a piece of land to expand his park. If Walt Disney is known to be the principal, the owner might increase the price because they know this is a big time company. If they really want this, they'll pay more. Right? So Walt Disney might come to me and say, James, I want you to be an undisclosed agent to buy this property so we can build on it. But I don't want you to disclose that it's Walt Disney because I know the price. So I go and I find a buyer and I say, hey, you like buying this property? What's your price? All right, I'm going to buy the property. James McDade. I'm an agent for Walt Disney, but I did disclose it to the seller. Right? Legal and lawful, yes. Who's liable? Me and Walt Disney. So if Walt Disney reneges on the contract, I'm liable. Think I'm going to want an extra amount of premium to be paid on that liability for Walt Disney? Hell yeah. Right? Undisclosed agency, though. It is lawful. It does happen. Yeah.
Can an employer ask an employee to act as an undisclosed agent?
Same liability, though.
Same exact.
Yep. Yeah, we talked about those. Okay. And the agent exceeds their authority or the scope of their authority, Joseph. When an agent enters into a contract, they give an implied warrant of authority. They're implying by doing the act of being an agent, they imply that they have the authority to do so. Right? If I'm acting as an agent, it implies that I have the authority to do that, right? If I don't, I breach the warrant of authority, implied warrant of authority, and then I will be liable to any third party who's been damaged. For liability for third parties, the principal and the agent are each personally liable. We're all personally liable for any tort that we commit, right? If I'm driving a car, regardless of whether I'm working for someone or not, and I hit a pedestrian, I'm responsible for liability, right? Whether or not my company is liable depends on certain circumstances, like what I was doing, when, where, and why. The principal is liable for the tortious conduct of an agent who is acting within the scope of his or her authority. The agent is only liable for the tortious conduct of the principal if he or she directly or indirectly participates in or aids and abets the principal's conduct. In the case of negligence, the liability is based on the doctrine of respondeat, that's spelled wrong, it's respondeat superior, which says that if a principal expects to derive a benefit from the acts of an agent, that principal picks up the liability for that agent's action. In other words, if I'm depending on Tomiko to do something for me, I pick up the liability if she screws it up. That's it. Some cases are frolic and detour. If an agent does something during the course of their employment to further their own interest over the principal, that's called frolic and detour. I'm on my way to do something for the principal, and I decide to get a strip joint on the way. Frolic and detour. Depending on how substantial the frolic and detour is, the principal could be held liable. If it's a small, insignificant thing, the principal will be held liable. So I'm on my way to do something for the principal, and I stop at 7-Eleven to get a soda, and I back out and get a pedestrian, the principal liable. Insignificant. However, if I'm on my way downtown to deliver a contract with the principal, and I decide because I have 7 hours to get there, because it's 9 in the morning, and I'm going to do that at, let's say, 4 o'clock in the afternoon, that's when the contract signing is to take place, and I decide to hop on a plane and fly to San Francisco for lunch with a friend, and I hit a pedestrian in San Francisco and fly back, the principal is not liable. Because that's a significant detour from what I was supposed to do. Understand the difference? Frolic and detour is dependent on what the court decides. They're going to look at how significant was the thing that you did. So if I'm going downtown and I stop in the 7-Eleven to get a drink for myself, which is not at all, something the principal asked me to do, and I back into a pedestrian, but it's on the way to my trip downtown, the principal still going to be liable. I hop on a plane and go in the opposite direction and come back and hit someone, frolic and detour. The principal's not liable. Don't have anything.
Oh, I did. I was curious about the distinction between what they did, something that's like soda or like a designated lingerie.
Designated lingerie principal probably liable.
I'm trying to look at the difference between agents where they would be liable for fraud and detour as opposed to an independent contractor. So let's say I hired a contractor and you went to Home Depot and you got an accident, I wouldn't be liable.
No, because it's an independent contractor, again, the distinction is controlling. With the employee, you're specifically controlling what they do. Go down there and do the contract. With the independent contractor, you're not. So it's completely different the way that it's looked at. In that the independent contractor is responsible for their own issues. There's 2 dangerous, you can't get out of liability by hiring an independent contractor. Okay? Or if you negligently hire an independent contractor, and you know that they were negligent. In other words, another tip to you guys. If you hire someone to contract on your home, make sure they're licensed.
That's right.
Because if they're not, guess what? You would be liable as an employer-employee relationship only because if the person is unlicensed, then it's called negligently hiring someone. You hire someone who's unlicensed to wire your house, the house burns down, you can't do that because you should have checked to make sure they were a licensed contractor. Okay? So anyway, dual purpose mission.
You were talking about the driver. I was just wondering if, like, they stopped at the bar and was drinking, and then went to do the job and hit the pedestrian. Would the company be liable?
Yeah. It depends on the situation. I was going to look at the situation, but they could be. Depending on, there's a case in your book that talks about them going, a group going out of town to do construction work. And during that construction, one of the employees gets wrong in the bar by over there. The court looked at how far removed that activity was from the work they were doing and found that the employer was not liable. So it depends on, again, how far beyond the scope of what you were hired to do. And there's another case in the book that I can look at.
What if it was company policy? The company policy is he cannot be drinking while riding his vehicle, like the UPS man, and then he drinks and drives. Are they not liable?
Well, then it depends. It's going to depend on the situation. It depends. A dual purpose mission is an errand or other act that the principal requests an agent to do while the agent is on his or her own personal business. Dual purpose mission, I'm on my way home. Would you stop by 7-Eleven or stop by Kinko's and do this? Make these copies for us. Dual purpose. I'm on my way home and I'll stop by Kinko's. Have an accident or his life. An intentional tort, the principal is not liable for intentional torts of agents and employees that are committed outside the scope of the principal business. There are two tests, the motivation test and the work-related test. Motivation test is what was the agent's motivation in committing the act? If it was to further the interest of the employer, employer's liable. If I'm on the job and I beat you up, Allison, because I'm jealous of your work performance, if we're working under the motivation test, then the principal is not going to be liable. Right? Because the reason I beat you up was because of jealousy. It wasn't because of some work-related issue. Right?
So, in terms of Joseph's example, he's talking about work-related actions. For the motivations, personal motivations to defraud and security and person who agency,
well, not necessarily. It depends on the jurisdiction and whether or not they use the motivation test. Because as you said in a second, the work-related test, which only applies to some jurisdictions. If the agent commits an intentional tort within a work-related time or place, the principal is liable. The agent's motivation is not relevant. So it depends on whatever jurisdiction you're talking about, whether they use the work-related test or the motivation test. If they use the work-related test, doesn't matter what the motivation was. If he committed the act in a work-related time or place, the principal is liable. Okay? Misrepresentation is when a principal is liable for the intentional and innocent misrepresentations made by an agent within the scope of employment, and that's when an agent makes an intentional misrepresentation that they know or should know is untrue. And innocent occurs when it's negligent. In other words, Robert asked me to sell his car and tells me it's been in an accident. I go find a buyer and I don't sell them. Whether it's intentional or whether it's misrepresentation. Guess who's liable? Robert's liable. is a person who is employed by the principal to perform tasks on behalf of the principal. The principal is not liable for the torts committed by independent contractors. What's the rationale? The principal doesn't control the way the work is done. So why should the principal make liable for a tort that they're not in control of? Again, the key to independent contracting is the level of control. Since the principal does not control the means by which the results are accomplished, the principal is not liable for the torts committed by the independent contractor.
Yes. So, philosophically, this is like buying a thing, which is buying a service. If you go to a store and buy something, or buy a roof,
yes,
you're buying a service.
That's not it. A principal is liable for the tortious conduct of an independent contractor involving the two things I talked about: inherently dangerous activities and the negligent selection of an independent contractor. So, in the case in the book, and we'll probably just barely get through this. We'll talk about social proprietorships on Monday. That's a quick one. In the book, there's a story about a young lady who buys a car and gives her car buys a car and uses the car as collateral to get a loan from a bank. She defaults on the loan. The bank sends a repossession company out to repossess the car. While they're repossessing the car, she runs out, jumps in the car, and locks the door. Repossession company puts the car on a tow truck with her inside and speeds to the repo yard. Drops the car off in the repo yard with her still inside and locks the gate and leaves with the Doberman Pinscher guard dog running around loose.
God, that's so illegal.
The police have to come and rescue the car owner from the car. She then sues the bank and the repo company. What's the court say? The bank says, we're not liable. We hired this repo company as an independent contractor. The court, to make a long story short, says, no. Repossessing a car is an inherently dangerous activity because people get shot and killed when they're out trying to repossess somebody's car. The person doesn't know you're a repo guy and thinks you're a carjacker, and they come out with a gun and blow your head off. Repossessing cars is an inherently dangerous activity. It's one that you can't skirt your liability by hiring an independent contractor to do it. So the court said the bank that made the loan and hired the repo company as an independent contractor was also liable for that tort that they committed because of inherently dangerous things. Everyone got that? Same with negligent hiring of an independent contractor. Again, you hire someone negligently, like an unlicensed contractor, and they screw up, you would be liable too because you shouldn't have hired them. According to the courts, not if it's done properly. You can argue that either way, right? But the court has a list of things that it considers inherently dangerous. And not only that, it's going to be looked at in situations, but some things are like burning down, like the sides of a mountain, to burn it down so that it's less fire danger. That's inherently dangerous activity. Mining is inherently dangerous. Use of dynamite to blow up things so that you can build a railroad or anything like that. Those are inherently dangerous activities. You can't skirt your liability by hiring an independent contractor. It's still liable. So again, independent contractors' degree of control is key.
I have a question. Are you inherently liable to the third party, or are you inherently liable to the person and to the other?
You're meaning who? The principal is inherently liable to the third party who is injured. The principal and the independent contractor are both going to be sued. Now, the principal might try to sue the independent contractor to be paid back for what they paid, but But they're primarily liable to the party into the third party.
If it's independent contractor, or regular course of business, if it's something inherently dangerous, is the principal inherently liable?
Situation.
Well, that's something you just have blowing up, dynamite. Everybody does.
Well, no, because the independent contractor is a mining company. It's their job. Yeah, it's their job. If I'm a mining company and you hire me, okay, I'm principal, and I hire you as a mining company to blow up this mountain because I want to build something, and you get injured.
Yeah.
You can't come back to me. I hired you as the principal. I mean, I'm the principal. I hired you as an independent contractor. It's your job to go and build. You assume the risk, but that's your business, right?
The concept of something inherently dangerous is liability.
With the third party. All right, that's all we have time for today. We have to chapter 2. We will finish up on the sole proprietorship on Monday, and we'll also deal with general partnerships on Monday. Okay? Any questions so far? It's in the afternoon. Well, afternoon. It's like 11:30. So it's in the yeah. You will be given 6.5 minutes to do 25 questions. No, you'll be given you'll have an hour to finish. Couldn't resist. Sorry.